Good to go, and the recording has started, Chair.
Okay, thank you very much, and thank you everyone for coming back to our meeting this afternoon of the Licensing Board for Aberdeenshire. I hope everyone had a good lunch and had the opportunity to get some of the sunshine that we are currently experiencing. So what we're going to do is we are going to move to item 11 on our agendas. Item 10 will be taken later on in the meeting as the agent is currently at another board, so we're waiting for him to arrive. So there were no declarations of interest for this, I believe, and this is the premises of the post office and convenience store in Kintore. So if I could ask the Deputy Clerk to outline the terms of the application and confirm the procedure for us, please.
Thank you. Just to confirm that the board convener made a transparency statement in relation to this application at the start of the meeting this morning on the basis that she knows the objector, but having applied the objectives test, it was a remote connection and she was going to take part. Unfortunately, for Mr. Clancy's benefit, the convener was called away this morning and is not yet back in the meeting. So the vice convener, Ms. Black, is in the chair. So although that transparency statement's been made, the convener is not actually in the meeting to take part in this application. The application is for a provisional premises licence. Is that right, Harriet? Yep. And there's been an objection to it, and although the objector is not present today, his written objection was received within time, and I'm sure Mr. Clancy will speak to the competency and relevancy of that in relation to the application. So the application couldn't be treated as non-contentious and is therefore before us today for a hearing to address the concerns within the objection. The procedure is set out within the report, and basically, as the objector is not here, hear from Mr. Clancy, ask questions of Mr. Clancy and his client if you so wish, concluding remarks, into debate, legal tests, make a decision. So that's the procedure as set out in your papers. Thank you, Chair.
Thank you very much, Fiona. So can I just confirm, Kevin, that you are present and that you are representing the applicant?
Yes, I am, and the applicant is joined by telephone.
Thank you. And are you satisfied that you have received all of the relevant information and do you feel able to participate in the determination of the application?
I do.
That's great. Thanks very much. Now, as has already been said, the objector is not present, so I will just go through with the procedure. In line with the guidance you've received in the public participant meeting protocol for licensing board hearings, please can you mute your microphone when not speaking if your device allows this. Please do not speak unless I invite you to do so, and please do not interrupt any other speakers. If you do, you may be removed. Once you have been asked to make concluding remarks, you're not entitled to speak again unless to answer a question from a board member. Once the board's made its decision, you'll be asked to leave the meeting. If the board requires to adjourn to deliberate the application, the recording of the meeting will be paused and the board will retire to a separate online meeting room. Please remain in the main meeting room until the board members return and I'll resume the meeting. And at that point, the recording of the meeting will be restarted, as will the live stream. So if I could just ask you then, please, to outline the terms of the application to the board and address why the board should grant a departure to local conditions in order to grant the application at this time.
Thank you. As has been noted, this is an application for provisional premises licence in respect of the post office and convenience store in Kintore. I intend to address the board briefly, firstly in respect to the background to the application, and then secondly, of course, in respect of the objection that's been received. At the outset, there's been positive dialogue with the licensing team in the preparation of this application. I would submit from the outset that this is an application that conforms to the requirements of your licensing policy and is entirely consistent with the licensing objectives. The applicant purchased the post office in November-December 2023 What is intended is a post office style of operation with a convenience store attached, selling a range of goods associated with the size and style of such premises, including groceries, dairy products, that sort of thing. The applicant is keen to ensure his business operation remains viable. He considers holding a premises licence to be an important, albeit ancillary, part of the business, and that's, in my submission, not uncommon for post offices and convenience stores. The grant of the licence will also ensure the ongoing commercial viability of the post office at these premises. And to give an example, if the licence were to be granted, the premises will go from one part-time and one full-time and two full-time members of staff. The proposed capacity is modest at just over 8 square metres. That reflects the limited range of beers and wines. The higher value premium spirits form part of the inaccessible area. That's partly from the point of view of security. But what I can tell the board is what is not intended is the sort of product such as ready mixed cans of gin and tonic, vodka and coke, that sort of thing. The applicant has no interest in stocking those sorts of products and also wishes to be a responsible neighbour in the community. This is an exciting and important venture for the applicant. He's aware of the licensing objectives and the board's conditions. He understands that once trading with a licence, getting it wrong could have consequences. And I submit that is reflected in the considered answers to your risk assessment questionnaire, such as the importance of staff training, age verification to ensure no sales to minors, a refusals log, and so on. There's one objection. But for the objection, no other issues have been raised, and I expect this would have been granted as a non-controversial application. No objections have been raised by the statutory consultees. The objector speaks of increased nuisance crime and antisocial behaviour through the consumption of alcohol. This is not an on-sales, of course, where customers may leave an establishment under the influence of alcohol. It's a post office with a very limited range of off-sales, and in my submission ought not to cause any nuisance or antisocial behaviour. Were it to be otherwise, Police Scotland and the LSOs would be quick to intervene. The objector speaks about a risk to children and young persons. The applicant is well aware of the importance of age verification and that the sale of alcohol to minors is a criminal offence. Through vigilance and staff training, these sorts of issues ought not to be caused by the premises. There's no evidence before the board regarding the police reporting that's alluded to, but in any event, since the premises haven't traded as an off-sales, it can't be said that this premises has contributed to any of the issues that the objector hints at. The applicant is very mindful of the need to require proof of age. Challenge 25 will be implemented. There will be training in respect of age verification. There will be ongoing monitoring to ensure staff and customers comply. Compliance will be recorded by way of a refusals book. Essentially, everything your policy anticipates. The issue of opening hours is not truly a licensing issue. If the post office opted to be open as a post office and retail unit until 9 p.m, even unlicensed, in my submission, that's not objectionable and certainly not a ground for refusal. And finally, the objector refers to over-provision. Now, it doesn't require me to submit. This board has already carried out a considered assessment of over-provision. There are no grounds for over-provision in Contour. Your assessment of over-provision concluded a saturation point for this locality had not been reached. These premises are significantly smaller than the two largest neighbouring off-sales premises. It's not a supermarket, it's a post office and retail unit. The applicant is aware the grant of a licence is a responsibility, one he takes seriously, and he wants to ensure that the premises operate responsibly within the community. The applicant will ensure compliance with the mandatory conditions as well as your specified local conditions, which, as your papers note, were considered and agreed in advance with your licensing team. So I submit none of the grounds of refusal apply, and I would move the application be granted. If I can be of further assistance, myself and Mr. Reddy are happy to do so.
Thank you very much for that. So as we have no other people speaking, if I can invite the board members to, if they wish to ask any questions. Okay, Mr. Taylor.
Thank you very much, Convener. Thank Mr. Clancy for his report and comments. He's emphasised it's a post office and convenience store. My question is, what are the hours at present? It indicates, the application indicates quite long working hours are proposed. Would these hours be similar if there was no off-sales licence approved, and therefore as a means of generating additional sales?
So to answer your question, and Mr. Reddy can correct me if I have this wrong, the post office and convenience store operates more like, I think, 6 AM to 6 PM or thereabouts, using the members of staff I've mentioned. The hours that have been applied for in the application reflect the statutory hours for off sales, and as I alluded to in my submission to the board, if the application were to be granted, an additional full-time member of staff would be taken on, which permits the hours to be adequately covered by the full-time and part-time employees. And the purpose of the application is, as I've already mentioned, to ensure that the convenience store is viable and the sort of ongoing commercial viability. So that is perhaps a long answer to the councillor's question. I might just pause there and check with Mr. Reddy that I have got the current opening hours correct. I have not misstated the position.
Hello.
Yep. Yes, Mr. Reddy, go ahead.
Hi. Yes, as Mr. Clancy pointed out, we are currently opening from 6 in the morning to 5:30 in the evening, and if the hours are granted, we would be doing until the hours mentioned. But if not, if the off license isn't granted, we will be closing at 5:30, which is our regular timing, because there is no commercial viability without off sales in that area.
Okay, thank you. Does anyone else have any questions? Okay. No. Okay, Mr. Clancy, can I ask you if you have anything you'd like to add in closing, remembering that you cannot add anything new?
No, thank you. I would simply be repeating myself. I don't want to unduly take up the board's time, so I would just re-emphasise my submissions and move the application be granted.
Okay, thank you very much. Okay, board, does anyone require legal advice from the clerk then, please? Okay, I'm not seeing any hands going up. I would just like to ask, please, just for clarification, we've obviously just heard that currently the store is open from 6 to 5:30, but should they be granted the licence, they would then stay open until 10 o'clock. How material is that in our decision making, please?
No, not really, because the premises could choose to open till 10 o'clock without the licence anyway, and you know, it would be planning restrictions that would enforce that rather than the licence, and the maximum hours that can be granted are 10 o'clock in any event. So in relation to the licence application itself, it's not material consideration.
Okay. Thank you for that confirmation, appreciated. Anybody else got anything on the back of that? No, not seeing anything. Okay, so in that case, can I please ask the Deputy Clerk to outline the terms of the legal test for this application, please?
Thank you, Chair. The legal test is as set out at page 667 of your papers, and that is, unless the board finds any of the grounds of refusal apply, the board must grant the application. If you find that any or all of the grounds of refusal apply, you must refuse. The grounds of refusal are set out at section 5 in your legal test, that the subject premises are excluded premises. I can advise that that does not apply here, that the application must be refused under certain sections of the Act. Again, that does not apply here. That the Licensing Board considers, having regard to the licensing objectives, that the applicant is not a fit and proper person to be the holder of a licence. I would consider there's no evidence being put before you today to justify that ground of refusal. That the Licensing Board considers that the granting of the application would otherwise be inconsistent with one or more of the licensing objectives. So you would have to weigh that up in light of what you've heard today. That having regard to the nature of the activities, the location, character, and condition of the premises, and the persons likely to frequent the premises, the board considers that the premises are unsuitable for the use of the sale of alcohol. Again, you need to weigh that up based on what you have before you today. And as the applicant's agent has said, and I will reiterate, that to grant the licence would result in over-provision of licensed premises, but the board's policy has indicated that there is no over-provision within the locality of Kintour. So I would advise that some of the grounds of refusal can categorically state do not apply, and the others you may need to weigh up in terms of the evidence that you've heard today, determine whether or not you find they apply. If you find that they don't apply, you must grant the application.
Thank you very much, Fiona. So would board members wish to retire to deliberate this application? No. Not seeing any indications, so I'll now open the matter for debate, please. Anybody got any comment they'd like to make? No? Okay, in that case, board members, can you please confirm that you've received sufficient evidence upon which to make a decision?
Yes.
Yeah. Yeah.
Yes.
Okay.
Yes.
In that case, can I call for a motion, please? Mrs. Nichol.
Thanks, convener. Yeah, I'll raise a motion to grant the licence. I think from what we've heard today, I don't believe there are any grounds for refusal for this one.
Okay. And seeking a seconder, Mr. Maynard?
Yeah, happy to second on those grounds as well.
Yeah. Great. So, in that case, I'm remembering this is also provisional, I think it is, Fiona, as well?
That's correct.
That's correct, yeah. Okay. So if I could just double check that is a unanimous decision of the board?
Yes.
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 Yes, I'm satisfied with that. We don't need to take a roll call, I don't think. So if you could confirm the board's decision then, please, Fiona.
So Mr. Clancy and Mr. Reddy, the board has granted the application today. Thank you for your time, and you're free to leave the hearing.
Thank you very much for your consideration.
Thank you very much for attending, and I can confirm that this is now concluded, and I'll now ask you to leave the meeting. Thank you. Okay, so our next item, I'm assuming we're moving to item 12. Harriet, can you just confirm to me that that's where we're going next?
I don't actually have the applicant present for item 12 either. They did indicate that they had a representative attending, however, there's nobody in the lobby.
Okay.
I don't know if you'd like to do item 13.
Yeah,
or I can certainly try and
Mr. McMahon hasn't arrived yet.
Yeah. Yes, he probably won't be coming till nearer 3. I can
Right.
certainly dial in the applicant for Burnabenny, but they are maybe watching on the live stream and are looking to dial in shortly. Up to yourself, convener.
Okay, well, we have got other items on the agenda. So what I suggest we do is we move to our policy papers for 13.1 and 13.2. And in the meantime, Harriet, maybe you could get in touch with the applicant for item 12, so we can do that afterwards, if that's okay with everyone.
Yep.
Okay. Good. So if so item 13.1 is the review of the board's equality policy and equality outcomes for 2025 to 2029. If I could invite the Deputy Clerk, Fiona Stewart, to speak to the report, please.
Thank you, Chair. You recall that at the last board meeting in February, we asked for authorisation to proceed with this review. We went out to consultation. You'll see from the report we've got very few responses, and we've provided an officer response to each of the consultation responses. I think there's a general misunderstanding about why we have to do why we have to have an equality policy and outcomes. It's a legal requirement of the board. We've set out our revisions to the policy in red in Appendix 1, so you can see the changes that have been made. Very few changes to the policy itself. I'm pleased to say that reviewing the evidence provided by Aberdeenshire Council, and we've been able to use their integrated impact assessment as well, that we are able to comply with at least 3 of the equality outcomes that they've set as joint equality outcomes, and we have reviewed our own equality outcomes and set new ones that are achievable for the next 4-year period. The next main reporting point in this will be the mainstreaming requirement in 2 years' time. What I would say is that we've taken cognizance of the fact of the outcome of the Supreme Court case in relation to the legal definition of woman. And as you'll be aware from recent press releases, we are starting to see some guidance coming through in relation to that. And we are asking, in addition to approving the policy and outcomes, that you authorise officers in consultation with the convener to keep the documents up to date as further guidance comes out in relation to how the definition of women will impact on the equalities policy and outcomes moving forward. Happy to take any questions, and I'd also like to thank Clark Simpson, our paralegal, for the work that he did in getting the policy revised and the consultation out and completed in time to bring it back to the board today. Today is the last legal day in which to have the policy updated and the outcomes set for the next 4 years. So I've taken it right to the wire.
Thank you, Fiona. And on that note, do members have any questions they'd like to ask? Mrs. Sullivan.
Part of what Fiona's just said was that she's seeking our permission basically to give delegated authority to update the policy. Is that correct?
Just to keep it up to date with the impact of statutory guidance following the court case in relation to the definition of woman, without having to bring the policy back to the board.
I'm not happy with that. I would rather it come back to the board.
Okay. Fiona, did you say that you would do that in conjunction with the convener?
Yes, that's what we're asking for, yeah.
Right. Okay. Thanks, Mel. We'll take that on board. Mr. Taylor.
Yes, thanks, convener. A question and a comment. Thank Fiona for her resume to date. On page 784, it speaks about being gender neutral, and I'm just going to inquire, does that mean that that it'll be changed to using plurals as opposed to singular?
Yes.
Thank you. And as far as, and you've already covered the engagement, that it is a statutory requirement, nothing to do, well, Aberdeenshire, the licensing board conducts the engagement, but it's forced upon us rather than us deciding upon ourselves.
It's not something that we have an option to choose to do. It's a legal requirement. I wouldn't quite use the term forced upon us, Mr. Taylor. It's a legal requirement.
Apologies for the slack use of language. I'll accept that it is a legal requirement. That's what I wanted to emphasise.
Yeah.
Thank you.
That's great. Okay. Does anybody else have any questions? Okay, what I'd like to do is I'd like to, before we go to the recommendations, obviously Mel has brought up that she's not content with recommendation D, which would be to essentially delegate authorise officers in consultation with just the convener to update the board's documents as regards the equalities for gender and trans people as suggested. So does anybody else have a view on that, please? Mr. Taylor.
Thank you. As it is simply an update, my view would be that we do authorise officers in consultation with the convener to update the documents.
Okay, Mr. Goodall.
Just trying to dig down a little bit as to why we should bring it back to ourselves. Is there anything that we can alter if we do, given that this is going to be, it comes from central government, as it were, and also from our officers, they'll be looking at how the new regulations and policy will apply to us. I don't see how we will be able to change that. And if we're not able to change that, then I'm quite happy with it going to officers and our convener. Perhaps I've picked it up wrong. If Fiona or whoever can correct me.
Yeah, Fiona.
It's
you in there?
We don't know what the contents of this guidance is going to be yet, so we don't know how it'll influence the terminology in our policy. Any fundamental changes would have to come through a legal change. This is purely guidance, so it's to make sure the terminology, the references in the policy are kept up to date with the terms of any guidance issued. So it shouldn't require any fundamental changes to the policy because the law itself is not changing. It's just the interpretation of terminology within the law. Officers are happy either way, but it's just to save a formal consultation with the board on what would be minor changes to terminology. But if the board wants it brought back to the board, then that's what we'll do. But it's the great unknown at the moment because the court case has been so recent. We just don't know what shape or form the statutory guidance will have. It's too early, and given it's 2 years down the line before we report again, just to keep that up to date. We have a similar authorisation in terms of the liquor policy and the gambling policy to keep that up to date with terminology and guidance in between formal reviews, but it's whatever the board wants.
Okay, thank you for that. And Mrs. Nichol, please, Jenny.
Yeah, thanks, Camilla. Just before Fiona spoke, I was thinking, yeah, I would definitely support what Mel was saying. But I think the problem is we just don't know what these implications are of this guidance yet. And maybe that unknown is why it should come back to the board. Maybe that's a reason there for us that actually we say, well, we would like to see it, even if it is something that comes to us and we want to just be aware of what's going on and have it noted.
Yeah. Okay, I would personally tend to agree with Jenny and Mel, just so that we do have it in front of us and it is within public papers, so that it is just for transparency and clarity for everybody. Would everybody be content then to change recommendation D, that policy outcomes and changes come back to the board if and when? Mr. Mason?
Well, we're not get the information back anyway. Surely it's
in 2 years' time, I think.
In 2 years' time,
when the review comes up.
The next formal reporting period is 2 years' time. Any changes that came through, we can do by way of briefing note, but if the board wants it brought back to the board, we're happy to bring it back to the board. Just put that recommendation in there because it's something that we usually ask for, just to keep it in a policy in line. But I'm more than happy to bring it back to the board if that's what the board wants.
Mr. Goodall?
Having heard what everyone said, I think it's quite reasonable for us to bring it back to ourselves. We don't know when this is going to come back. We don't know how complex it's going to be or how simple. We have no idea. So it might be a good idea, as Mel says, to bring it back to us.
Yeah. And Mr. Crowson, Jeff?
I think if it comes back to us, I'll make sure that we can all say that we've seen it and not claim to not have seen a briefing note or that in future references.
Yeah, I would agree. And also for the point of putting it in front of the public in the papers as well. So I don't know, Fiona, do we need to take a roll call on that, or
No,
consent?
I'll get the wording for that amended, that the board would prefer that any further amending as a result of guidance produced would come back before the board. And
Okay.
if that satisfies the board, then if you're happy with the rest of the recommendations, I can take silence or a yes as a unanimous agreement.
Yeah, I'm content with that. So quickly then to run through the recommendations, we are considering the responses made following the consultation, as outlined in appendices 2A and 2B. We've considered the terms of the officer's advice in respect of the consultation responses, and we have agreed the terms of the equality policy and outcomes for the period 2025 to 2029 as set out at Appendix 1 to the report, and authorised publication of it to the board's website. And we are altering recommendation D so that any changes to the wording because of the Supreme Court case comes back to us.
What I would say is that you've noted the outcome of the case, but that any changes would come back.
Changes would come back. Yeah, that's fine. Is everyone agreed?
Agreed.
Yep, happy?
Agreed.
Agreed. Yeah.
Okay then.
That
Now,
takes us to 13.2.
Takes us to 13.2. However, Harriet, I think, has got.
I will wait till item 13 is concluded.
It's completely done. Okay, that's no problem. Okay, we will quickly then do the item 13.2, which is the review of the board's statement of licensing principles 2025 to 2028 according to the Gambling Act of 2005. So if I could ask the Deputy Clerk to speak to the report, please, Fiona.
Thank you, Chair. And first of all, I would offer an apology to the board. This review should have been completed by January of this year. However, due to staffing circumstances within the licensing team, this dropped in priority and we were not able to pick it up until after I was back in post. There is no penalty against a board who fails to do this, and I can confirm there has been no prejudice to any operator under any licence or permit that we have issued. I'm seeking approval to commence the consultation on the review of effectively is the equivalent of our licensing policy statement under the liquor legislation, and this has to be done every 4 or 5 years. The Appendix 1 sets out a timeline for how we're going to achieve this, and we are in the process of going through the existing statement against the Gambling Commission advice to have a draft policy to put out to consultation. What I will say is there's very, very unlikely to be any changes to the current document. Having briefly read through the Gambling Commission document, it's likely that the terms of our existing document will remain very much the same as it is. It's not as big a consultation as the liquor licensing policy, but all we're seeking at this stage is the authorisation to conduct that review and bring back the revised policy for 2025-2028 back to the board for approval at a later date, and we will have update reports for the board as to how the consultation is commencing or is taking place, so that you're kept updated before the final approval of the document.
Okay, thank you, Fiona. Does anybody have any questions for Fiona? Mr. Crowson, Jeff?
No, I was just going to say I'm happy for consent for it to move forward.
Yeah, fair enough. Anybody else got any comment or question they would like? I think this is a very straightforward matter. We're just giving permission for the process to start, essentially. Yeah. Noting the timeline that's within the report, and fingers crossed we'll manage to keep to it. Okay, so formally then, can I just go through those recommendations? We are noting the requirement to review the policy. We are agreeing the timeline for the review of the statement, and we are authorising the clerk to the board to conduct the review in the terms of the Gambling Act 2005. Are we agreed?
Yep.
Agreed.
Agreed.
Okay, super.
Agreed.
Well done. Thank you very much, everyone. Okay, so if we could now go back, Harriet, I believe we have the applicants and the agents for items 10 and 11. waiting, is that correct?
I have Brian McMahon for the objection, and I have the repeated occasional. I have Mr. Morris on the line. Happy for me to admit them both, convener?
Yes, yes.
So that would be for item 10 and item 12.
10 and 12.
Yeah.
Because
Yes.
we've done 11. Yes, sorry, thank you.
So I'll invite Mr. McMahon in first for item 10, and then once I have him in, I will invite Mr. Morris in for item 12.
Okay, thank you.
Hello, Mr. McMahon.
Hello.
Hi, Mr. McMahon. You're into the Aberdeenshire Licensing Board meeting. Can you hear us okay?
I can, thank you.
That's perfect. I just have another applicant to invite into the meeting. So what I will do is I will just pop you on mute, Mr. McMahon, just now. And when it's your time to call forward, please just unmute yourself.
Thank you.
Hello, Mr. Morris. Mr. Morris?
Oh, hello. Yeah.
Hi, Mr. Morris. It's Harriet from Aberdeenshire Council. You're into the Aberdeenshire Licensing Board meeting, Mr. Morris. What I will do is I will have to mute you just now until it's your time to be called forward. And when it is your time, if you click *6 on your telephone to unmute yourself, and you'll be able to speak.
*6, okay.
*6. That's perfect. Thank you very much.
Okay.
Thank you, Chair.
Thank you, Harriet. Okay, so we're moving on to item 10 on our agendas, which is the application for a provisional premises licence for a hearing because of objections at the Key Store in Ellen. I would just ask now that the Deputy Clerk confirms the procedure for the hearing, please.
Thank you, Chair. The first point I would like to make is that neither of the objectors are going to be present today. They are advised that the hearing can take place in their absence. Their written objections would obviously still stand. Are you content as a board to proceed in the absence of the objectors?
Yes.
Content, yeah.
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 So the procedure as is set out in Appendix 6 of your papers, you'd hear from the applicant. Obviously, the objectors are not present, but you can consider the terms of their submission, and I'm pretty sure Mr. McMahon will address the terms of the objections in his submission. You can ask questions of Mr. McMahon, invite closing remarks. You can choose to adjourn to deliberate or deliberate in public and then move to a decision. Thank you.
Thank you very much. Okay, Mr. McMahon, then if I could ask you to unmute and confirm your presence.
Good afternoon, Chair.
Good afternoon. So can I just ask you, are you satisfied that you've received all the relevant information, and do you feel able to participate in the determination of this application?
I am, thank you.
Thank you. If I could ask you to give your representation to the board then, please.
Yes, good afternoon, Your Honours. Brian McMahon representing Akio Retail, who operate the premises. The application before Your Honours for a provisional premises licence for Key Store at 131 Station Road in Ellen. As background, the premises operate as a traditional newsagent and a small grocer for a number of years. I think one of the objectors suggested something akin to 45 years. The newsagent's model, as Your Honours will be aware, is no longer viable, and my client has refurbished the shop, making it into a small and compact modern-day convenience store. Again, as background, good modern local neighbourhood stores are a community asset. You know, whether it be busy families for a top-up, or other customers, including elderly customers who prefer it as an alternative to large out-of-town supermarkets. Many people rely on their local neighbourhood store, with the average shopper visiting this local store 3.5 times per week, and with 56% of customers on average choosing to walk as a mode of travel to stores. The store offers a compact range of products, as you would expect: fresh foods, food to go, standard grocery and national lottery. Obviously, being able to have a full range of products is absolutely key in a convenience store, and we'd like to thank Your Honours for allowing us to participate with selling alcohol with a occasional licence for the last number of weeks. At the moment, alcohol sales amount for about 8%, so it is ancillary to everything else we do, and well below what would be expected in a normal convenience store. My client's an experienced retailer. He's worked in a number of small convenience stores in Aberdeen and Aberdeenshire, but this is his first venture into operating his own premises. He takes his licensing responsibilities very seriously and understands the importance of compliance with all legislation. The proposed store opening times are 7 AM through till 10 daily. However, it's likely the full hours will not be traded immediately, and this is something we'd evolve into as the business grows. I would suggest the proposed capacity of 12.1 is modest but probably appropriate for the range of products and the size of the store. The store, as I said, has operated since mid-February with occasional licences, and to my knowledge has been no problems either for the neighbours or for the local police. To address the objections, we can understand any nervousness when something new such as this is happening. If I could just go through, the board report has stated that over-provision is not a consideration for this application. There's been a number of comments on parking. Whilst important, it doesn't obviously fall into the remit of the Licensing Scotland Act. However, we do expect over 50% of our shoppers to walk and do not envisage parking problems. If there is an issue, then my client would obviously deal with that with the relevant authorities and the neighbours. With reference to noise, my client is in ongoing discussions with the property owners and residents above, and it's my understanding that the concerns raised has been resolved, as my client is keen to have a harmonious relationship with them. Regarding antisocial behaviour, we know Police Scotland have made and raised no concerns. My client will obviously operates Challenge 25 through his electronic till system, and anyone under 25 attempting to purchase alcohol would be challenged. He takes the view he would not compromise his business investment selling alcohol to anyone underage. The trading since opening has actually suggested there are very few young people attempting to buy alcohol. I can advise the food to go is purely pre-cooked bakery sandwich type products being sold over the counter, and no cooking as such is done on site. My client is conscious of noise and is minimising this. Again, it seems that the neighbours are happy with it. For the avoidance of background music, the definition that I would suggest is that if we're having a conversation, then we don't need to raise our voices because the music's been put on, and should be no issue at all for the neighbour. In summary, I believe this is a competent application that seeks to provide a new convenience store to the area of Ellen, which has not had one for a lengthy period of time. My client has made significant investment in the store. He's keen to foster positive relationships with his neighbours, which will obviously turn the business into a success. He's happy to accept all conditions outlined in the board's papers. As there's been no adverse comment from council officers or Police Scotland, I would commend the application to Your Honours subject to questions.
Thank you very much. Okay, so I can ask the board if they have any questions for Mr. McMahon. Mr. Taylor.
Thank you, Convener. Thank you, Mr. McMahon, for your contribution. The objection raised issues in relation to noise, and you've already commented that discussions, arrangements have been are ongoing, and you understand it to be resolved. Can I ask how they've been resolved?
I think that the gentleman above, from what I gather, and apologies if I'm fairly loose, and this is what I'm giving you as I understand it, used to actually run the store. And I think he had a number of concerns, earlier deliveries, etc. And, you know, things like papers are just so much not not an issue now, but obviously early delivery of papers, you know, before 5, 6 o'clock in the morning. So it's things like that. Deliveries through the front door seem to be less of a problem than he was expecting them to be. I think the deliveries to the back was the common way of doing it. Now they take most of the deliveries through the front, and it hasn't been the issue they expected. I haven't changed my submission since I had found out the objectors weren't going to be here, but I would suggest one of the reasons, or two of the reasons they're not here, is both are fairly happy with what they've had in the way of discussions and obviously actions from my client.
Okay, thank you.
Thank you.
Does anyone else have any questions? Okay, I had one. I just wanted to check. I mean, in the submission, it says that you had that the applicant is looking for 12.1 metres squared. What is that in proportion to the overall percentage, or percentage in relation to the overall display space within the store?
I had a quick look earlier. Unfortunately, the drawing I've got is not the best one.
No.
I think you know. I apologise for that. Mine is worse than yours. I'm not going to show you it. And unfortunately, I managed to print it in black and white. Getting a colour printer to work seems to be beyond the technology in Glasgow. I would say it's got a very, very big back store, but I would say overall it's probably about 15%.
Right. Okay.
I mean,
That's
when I say it's a compact store, it is a fairly compact store. And when you're trying to work out how much room to give alcohol, it's really just a case of having enough for white wine, red wine, rose, you know, and by the time you put in all the key things, you can't really go much below that.
No, that's fine. It was just that relationship between that and the rest of the store that was my concern. Okay, thank you very much. Anybody else? Or I will move on. Okay, so Mr. McMahon, do you feel that you need to sum up at all?
No, I think you've heard enough from me, Your Honours.
That's fine. Thank you very much.
There's a lot of nods there.
It's been a long day already. So if I can ask members then if they need any legal advice from the clerk, please. No, I'm not seeing any indications. So in that case, Deputy Clerk, please could you outline the terms of the legal test for the application? Yeah.
Thank you, Chair. The legal test is set out at page 613 of your papers, and that is that if the board find none of the grounds of refusal apply, you must grant the application, and if you find any of the grounds of refusal apply, you must refuse. And the grounds of refusal are set out at subparagraph 5, and they are that the subject premises are excluded premises. I can advise this does not apply here. That the application must be refused under certain sections of the Act. Again, I can advise this does not apply here. That the Licensing Board considers, having regard to the licensing objectives, that the applicant is not a fit and proper person to hold a licence, and I would advise there's no evidence being placed before you to justify a finding under this ground of refusal. The ones that you would consider, based on the evidence that you've heard today, are that the board considers the granting of the application would otherwise be inconsistent with one or more of the licensing objectives, or that having regard to the nature of the activities, the location, character, condition of the premises, and the persons likely to frequent the premises, the board considers the premises are unsuitable for use of the sale of alcohol. And finally, as we've already heard, the board has no finding of over-provision, so the final ground of refusal would not apply in this case. So if you find that either subparagraph C or D apply, then you must refuse. If you find they don't apply, you must grant.
Okay, thank you very much. That's very clear. Do board members wish to retire to deliberate at all? No, not seeing anybody indicating, so I'll open the matter to debate for members, please. Who would like to start us off? Mr. Mason.
Yeah, just I live in the area and I'm quite familiar with this particular store, its position and everything. I think I can't see a problem here. I think it is a reasonable application. Thank you.
Okay, thank you very much. Mr. Taylor, Ian.
Thank you very much. the fact that this individual has operated a number of similar convenience stores, both in the Shire and in the city, and this is his first venture on his own account. He's invested a bit of money, obviously, and I just can't see how such an individual would not wish to make sure that everything was going to go well in terms of meeting the board policies, being thoughtful for his neighbours, and therefore, like Mr. Trevor, like Mr. Mason, I don't see there's any grounds for refusing this particular application.
Okay, thank you very much. Anybody else got any views they would like to say? No, not seeing anyone further. Okay, in that case, can I ask members if you have received sufficient evidence? Oh, Mr. Mason, is that legacy still, or is that going back up for a motion? Yeah, okay. Confirm that you've received sufficient evidence upon which to make a decision.
Yes.
Yeah,
Yes.
happy? Okay, in
Yes.
that case, I will call for a motion, please. Mr. Mason.
Yes, I would like to propose that we grant the license on the same terms as the recommendations.
Okay, thank you. And we're looking for a seconder. Mr. Taylor.
Yes, happy to second.
Yeah, okay. Fiona, do we need anything further for the motion?
No, not for the motion, because it was made clear that none of the grounds of refusal apply there. Is there an amendment?
Yes, that's the next question. Is there an amendment? Anybody otherwise minded? No. Okay, I'm seeing no further indications. So in that case, can I ask, is the decision unanimous?
Yes.
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 Okay, everybody's happy. That's good. Thank you very much. So in that case, can I get the Deputy Clerk to confirm the board's decision, please?
Mr. McMahon, just to confirm, the board's decision today is to grant your client's application, and thank you very much for coming to the hearing. I understand you've had a busy day attending more than one board in one day, so
this was the most important one, though.
And thank you very much for coming.
Yeah. I'm very glad that we could grant that for you and do it relatively quickly too.
Thank you very much. I'm much obliged.
Very welcome. Okay, so that is confirmed that this hearing is now concluded. Thank you for your interest, and we will now ask you to leave the meeting. Okay, is everyone content to move on, or does anyone need a comfort break? Just got one more item to go. Mr. Taylor, your hand's up.
It shouldn't be. Sorry, I'll try and
That's
take it
okay,
down.
no problem. Is everyone content to just keep going then? Yeah, okay. Right, so we're now on to item 12, which is the granted a hearing because of the granting of repeated occasional licenses for Burner Benny Distillery, Hill of Banchory in Banchory. So can we confirm that we have the agent? Is it Simon Morris? Mr. Morris in the meeting?
Yeah.
Super.
I'm here.
Okay, good. So for your benefit, Mr. Morris, I realise I didn't do it in the last hearing. I apologise. I am going to read out the guidance for the public participant meeting protocol. So please, can you mute your microphone when not speaking? If your phone permits this, please don't speak unless I invite you to do so, and please do not interrupt the other speakers. If you do, you may be removed. Once you have been asked to make concluding remarks, you are not entitled to speak again unless to answer a question from a board member. Once the board has made its decision, you'll be asked to leave the meeting. If the board requires to adjourn to deliberate the application, the recording of the meeting will be paused and the board will retire to a separate online meeting room. Please wait in the main meeting room until the board members return and I resume the meeting. And at that point, the recording will be restarted, as will the live stream. So if I could now ask the Deputy Clerk to confirm the procedures as well.
Thank you, Chair. We should also have, I believe, is it Keith Simpson, the LSO, present for this hearing? Is that right?
Yes,
Yes.
I'm present, Fiona. Yep.
So the procedure will be to hear the applicant, to hear from the Licensing Standards Officer. The applicant will then be given the right of reply. You can question then either party, concluding remarks in reverse order before then moving to make a decision. Thank you, Chair.
Thank you very much. Just getting my notes in order here. Okay, so can I ask you, Mr. Morris, to outline the terms of the applications to the board, and you may wish to address the concerns that have been raised in the representation at this time in relation to repeated occasionals, although you will get to speak further and address the board again after the other parties have spoken.
Okay.
Please, yeah.
Well, you have to excuse me because I've never done one of these before, but the reason that we've been applying for occasional licensing is because we weren't entirely sure what type of license that we were going to apply for. We are in the process now of applying for a full premises license for off sales. We've since changed direction because we were going to do on and off sales. But because of our infrastructure of the building, we decided that it would be better to concentrate on the off sales. And in the interim, we were advised that we could use the occasional license system until we could get that. Given the way that the whisky market has changed somewhat, we've had to diversify. And the main purpose of our application for a license is purely e-commerce. And that's basically the outline of it. There's various things that you need to do in order to have an Amazon shop, etc., etc. And like I say, the main focus is for the purpose of e-commerce.
Okay. Is that you completed your submission?
Yes.
Thank you very much. If you could just go on mute now, and I will ask Mr. Simpson if the LSO to speak to his representation. Thank you.
Okay.
Yes, thank you, convener and board members. The applications before you are for 4 occasional licenses made by personal licence holder Lucy Scott for the premises known as Burnabenny Distillery. The applications were submitted on the 14th of March this year and cover a period from the 2nd of May this year to the 26th of June inclusive. These applications are the most recent in a series of occasional licenses dating back to the 1st of December 2024. The applications are for the sale of both on and off sales, 10 AM till 10 PM, with the on consumption taking the form of tastings. The premises themselves are 4 industrial units within a commercial area of Hill of Bankery near Bankery. To date, there has been no application for a premises licence. Given that the premises have been running on occasional licences for more than 3 months, I consider these applications to be inconsistent with para 4.45 of Supplementary Policy 4 of the Aberdeenshire Licensing Board Statement of Licensing Policy 2023 to 2028. The purpose of my representation is to make the board aware of this potential breach of policy and for you to consider the matter. If the board are minded to grant these applications, my proposed conditions to be applied are set out within my letter of representation. Thank you, Chair.
Okay, thank you very much, Keith. Mr. Morris, would you have anything further to say, having heard Mr. Simpson's submission?
No, I understand. It's we were advised in the early stages that the continual application for occasional license would lead to today. So,
yeah,
no.
Okay.
I have informed the LSO that we are in the process, and he is aware that we are in discussions with Tony Dawson from James and George Colley, who has the application, and he's right, it hasn't been submitted yet, but we have changed direction somewhat, and from what I understand, well, I know for a fact that Tony's had 2 knee replacements, and each time we go to have a meeting, it seems he's having another knee operation, but I believe he's back and we plan to get onto it pretty quick.
Okay, thank you very much for that. Members, if I could ask you if you have any questions for either the LSO or for Mr. Morris, please. Okay, here we go. Mr. Maynard, just taking a while for those hands to go up. Mr. Maynard, Richard.
It's just to clarify the change of direction that you're proposing. At the moment, your applications are for on and off for tastings. I take it that you're going to stop all of that in the future and just rely on off sales without anything. Is that what you're proposing?
Yeah, that's exactly. We understood it that it would be best to apply for on and off sales in the full application, but we've considered the operation and the health and safety and the infrastructure that we don't currently have to accommodate an on and off, and also it just doesn't fit with the business. So our intention is purely off sales and not on sales, because we're not set up for it. We know that.
Okay.
Thank you so much.
Thank you very much, Mr. Taylor. Ian.
Yes, thanks, Convener. Could I ask Mr. Morris, well, albeit, and it's unfortunate that the legal advisor, his legal advisor, has been unavailable to work for a time, but could I ask for a specific date when the premises license is likely to be submitted? That's the first question. And secondly, on the e-commerce side and off sales, I'm presuming there'll be a record as far as age for purchasers is noted.
Yep. So question one. Sorry, remind me, what did you say question one was?
When the premises license is likely to be submitted.
Oh, I see. Well, it was about 3 weeks ago that he told me that he'd be out for 3 weeks. So he's due an imminent call. It will be with the most urgency. So I'd like to think in the next week or two, I'll be sitting down with him and getting. He has all the paperwork that was given to us in order to make the application. I believe he started it before the second knee operation. And subject to this meeting, I mean, imminently is the plan. There's not going to be any delay. As soon as we can get a meeting with him, we will do it. And as for the second point, yeah, everything will be in place for the 10 to 10 operation and age verification through our courier services.
Thank you.
Okay, thank you very much. And Ms. Sullivan, Mel.
That was going to basically be my question as well. Will the paperwork be submitted and go through before the last lot of provisional licenses runs out? Would that be more of a question to Keith Simpson, though? That if they did get their paperwork in pretty soon, would it get through, or would we need to hear them again? Or is that when we do the whole delegated authority to do the next batch?
Okay.
I'll leave that to
question, Mel? Yeah.
I'm sorry, my question seemed to diverted from one person to the next, and then Fiona, because she was looking at me.
It's okay. What I would say is that we have up to 6 months to process an application for a premises license. Given that it's not in, and obviously the applicant's agent here today is not able to give us a definitive date because of the circumstances of his legal advisor, I would say the possibility of having it processed for the June board is doable if everything is straightforward, but it depends on how close to the June board that application comes in. So I would be saying it's highly unlikely, and it may be the August board. The occasionals that you're being asked to consider today take you up to the June board. So it may be that you're satisfied that there is a premises license coming at the moment and you wish to delegate future applications to officers in consultation with the convener, or you may wish to try and keep this on track as we don't yet have a premises licence in, and say future applications will come back to the June board for further consideration. It's open to the board to decide either way. If a premises licence application had been in and was underway, I could perhaps have given a stronger guarantee that we would have that at the June board, but at the moment, effectively, it's how long is a piece of string, because we don't have that guarantee. And there are processes that have to be gone through before we can get an application to the board, as the board members are fully aware. I appreciate the applicant, everything seems to be moving in the right direction. I accept that his hands are tied because he can't speak to his lawyer, but that we don't have that application in, so we don't have that guarantee yet.
Thank you for that. Happy with that, Mel? Yeah. Okay, good. I have just one question. Considering your submission, Mr. Morris, that when you come round to doing your full licensed premises, you're planning just to do off sales. Now the occasionals have been put in for on and off. Would you be content for those just to be for off sales? The occasionals that we are looking at granting or not granting today?
Well, we're not taking any advantage of the word on in any way since we've had them, other than we did do some pop-up things during Christmas, but that was opening the hatch and selling it, as a pop-up outside the door. So. To answer your question, it's a possibility. I would just stress that the reason that we've had to do this is because we've had to diversify quite badly, given the way that the whisky market has changed, not helped by, and quite rightly shone light on whisky bandits and people like that. So we've had to diversify into rum and all sorts in order to make money, and we rely heavily on that stream. In order to pay everyone's wages, that's me being straight with you. So if it means taking the word on off, then so be it. Because like I said, we don't honour the word on in any way, shape, or form. We just rely on the online sales that we're using.
Okay, thank you for that.
Okay.
Does anybody else have any questions before we move on? I'm just trying to get my computer to cooperate with me. So we've had all our questions, nobody else is indicating, so going in reverse order. Mr. Simpson, would you wish to say anything in closing?
No, nothing further other than to maybe ask the clerk with regards to the removal of the on sales, whether that will have an impact on the conditions that may be attached to the occasional licenses, and whether they're looking for an amendment and an agreement from the applicant on that. But that's maybe a legal matter more than anything else. But I've got nothing further to add on the applications themselves other than that.
Okay, thank you very much. And Mr. Morris, would you wish to say anything extra in closing, remembering that you can't add any new evidence at this stage?
No, I think I've been as straight as I can be. I can't guarantee anything, but it's high on priority that we speak to Tony from James and George Colley and get the ball rolling. And that's all I can say. And I have been frustrated with points, but I can't help it. Other than seeking another lawyer, but he is our lawyer. I will, let the panel and yourself know that I will be working very hard to get that application in imminently. Okay, thank you very much for that, and we do appreciate your straightforward, honest answers. If you could now mute yourself. So Fiona, first of all, I'm going to open it up to the board if we require legal advice from the clerk, but Fiona, if I can kick that off with reference to what Mr. Simpson said there, if we did decide to change to just off sales, would that change the conditions?
It would be, I would suggest, a reduction in conditions possibly some slightly different ones, which could be done in negotiation. We'd have to take into account the recommendation of the police as well in relation to those conditions. But if we can come to an agreement with the applicant, it could be the applications could be granted in principle, subject to those amended conditions being put into place.
Right.
Should be quite easy to achieve.
Okay. Thank you for that, Mr. Mason. Trevor.
Yeah, well, just a quick one about is there a cost reduction for taking off on sales, or is it exactly the same?
No.
The application fee is £10, Mr. Mason, and it's to cover the cost of processing the application, and the processing is the same whether it's for on, off or both. So I'm sorry, that's not something we're able to offer the applicant at this point in time.
I was just wondering what the benefit was of just taking off on sales.
If the applicant, as he has quite clearly stated in his submissions today, is stating that he's not using the on sales, then what we're suggesting is amending the licenses that we grant on occasionals to suit the work model that the applicant is actually working to. So it just ties it more closely in to the way that the applicant is working. That's the only reason that the board should consider amending the applications in that regard.
Okay, thanks. Yeah.
Okay. Any further questions for Fiona? No, not seeing anybody. Okay, so in that case, can I ask you please to outline the terms of the legal test for the application, please, Fiona? Thank you.
Thank you, Chair. I just had them up a minute ago. Here we go. Again, it's a must grant, must refuse situation. Must grant if none of the grounds of refusal apply, must refuse if they do. And the grounds of refusal are, again, that the application relates to excluded premises, which doesn't apply. The application must be refused under certain sections of the Act. Again, that does not apply. That the board considers the granting of the application would be inconsistent with one or more of the licensing objectives. That having regard to the nature of the activities proposed to be carried on in the premises, location, character and condition, and the persons likely to frequent the premises, the board considers the premises are unsuitable for use for the sale of alcohol. In line with the repeated occasionals policy, I would remind the board this is not necessarily about finding that grounds of refusal applies. It's about ensuring that the applicant is working towards the proper licence for operating the premises, which is a premises licence. So it's just paying closer scrutiny to the way the applicant is trading and the licences under which he's trading. My advice would be there's none of the grounds of refusals apply today. So the board's decision is, are you content to grant as applied for, as amended for off sales only, in principle subject to agreed amended conditions, and moving forward, do you want future applications brought back to the board given that there's no actual premises licence lodged at the moment, or are you content to delegate that to the convener and the convener can refer back to the board in due course if no premises licence is lodged with us? So I'd say that your options today are about granting and how you grant rather than refusing. Thank you, Chair.
Thank you, Fiona. That's quite clear. Do board members wish to retire to deliberate? No. Okay. I'll open the matter to debate. Anybody want to go first? Okay, Mr. Masson.
Yeah, I would have thought the applicant would be desperate to get a premises licence. Because they produce whiskey and they can't sell it. That seems it's not very good when you produce something and you can't sell what you've just produced.
I would temper that with saying the license is about retail sale, so there'd be nothing to prevent the wholesale of whiskey.
Oh, right, okay.
And also that the fact that the applicant has made it quite clear that it's due to circumstances beyond his control relating to his legal advisor that has postponed the submission of the premises licence. So it's not entirely within the control of the applicant today when that premises licence gets lodged, because he quite rightly has to have the proper legal advice before he lodges that application.
Okay.
Yeah. Thanks for that, Fiona. Mr. Taylor, Ian.
Thank you very much. And I thank Mr. Morris for, as you've already commented, convener, his honesty, frankness with us. And with that, you know, I don't see any grounds for refusing this application for the occasionals. Indeed, and to keep it simple, I'm inclined to leave it the way it is for both off and on sales, albeit that Mr. Morris has indicated he's not using the on sales. Future application that should take the occasionals through to I think it was about the end of June. Future applications, I'm thinking, should come back to the board. Thank you.
Thank you very much, Mr. Taylor. And I've got my hand up there. Yeah, I'm in concurrence with Mr. Taylor there. I would agree with everything that he said there. What I would say, though, is when it comes to bringing things back to the board, I would say if we can condition it that they only come back to the board if a full licence application has not yet been submitted. If a licence application has been submitted, then there's no need for it to come back to the board. Mr. Menard, Richard.
Yeah, actually, you've taken the words out of my out of me. I concur exactly with what you've said. Thank you.
Yeah. Okay. Thanks very much for that. Okay. Anybody else? No, not seeing anybody. Okay, so can I just ask for you to confirm that you've received sufficient evidence upon which to make a decision today? Everybody content?
Yeah.
Yes. Yes. Okay. In that case, can I call for a motion then, please? Who's going to go for it? Mr. Menard, Richard.
Yes. My motion is that we grant these applications for occasional licences, subject to LSO local conditions, and the subsequent applications should be delegated to the officers and the convener, on the understanding that should an proper application come through, that it would then have to come back to us after a period of time. Does that make sense?
I don't think you've got that quite right.
No, not quite right. I think they would need to come back to the board unless a full application has been received.
That's correct. Yeah, that's what I meant to say. Thank you.
Yeah.
So the motion would be to grant the current applications as applied for, subject to the conditions recommended in the report, and that future applications for occasionals only come back to the board where no premises licence application has been lodged. Where a premises licence application has been lodged and is being processed, officers will keep an eye on that in conjunction with the convener, and will only bring it back to the board if there are issues with the processing of the premises licence itself.
Yeah.
Correct.
Okay, so looking for a seconder, Mr. Mason.
Yes, I'm quite happy to second that.
Super.
Now I've got it detailed. Thanks.
Okay, just to clarify on the motion as well, we're talking about the June board, because I think that's around the same time as these occasionals run out.
25th of June, I think it is.
25th of June. So yeah, so there's a day there that we have in hand, because the board is the 25th and the occasionals run out on the 26th. So should a license should an application not come in, we would hear any further occasionals we would hear at the next board.
Yeah. Yeah,
Okay.
applications for the next occasionals have to be in at least 6 weeks prior to the expiry of the last lot on the 26th of June. So there will be occasionals in, but we'll keep it to the last minute for a premises license to come in before dealing with those.
Yeah, okay. Mr. Mason, your hand's gone back up. You're muted.
Did we say it's going to be on and off sales? Or just on sales?
Just as applied
just
for.
as applied for, Mr. Mason.
Okay, excellent.
Yeah. Okay. Is everyone content with that, or is there an amendment? Okay, I'm seeing no hands, so can I take it that that is a unanimous decision?
Yes.
Yes. Okay. So can I please ask the Deputy Clerk to confirm the motion and or confirm the decision? Thank you.
So the decision of the board is to grant your applications today as applied for, subject to the conditions recommended in the report. And with regard to future applications, if there is no premises licence lodged, future applications will come back to the June board for consideration. If there is a premises licence lodged, we'll continue to deal with occasional applications under delegated authority in consultation with the convener, and we'll only bring them back to the board if there are issues relating to the processing of the premises licence. We'll get those licences out to you as soon as possible, and thank you for attending the hearing today.
Okay, Mr. Morris. Is he gone? No, I think he's still there. Yes.
Yeah, sorry, I had to figure out how it worked the phone there for a minute.
That's okay.
Yeah, all noted and gratefully received. And I should note that we focused mainly on whiskey cask investment initially, so that's why we weren't. Yeah. Okay, that's great. But that's your occasionals up until the end of June, granted. So we'll just look forward to receiving your full application in due course. Thanks very much. Thank you.
Thank you very much.
Okay, thanks.
Okay. So I can now confirm that that's all business dealt with, and just ask you to note that the date of the next board meeting, which is the 25th of June 2025, as already mentioned. If we could stop the recording, please, and the live stream. Thank you for your interest in the business and your participation in the meeting today.